like to take this opportunity to thank Malaysia HR Forum for organizing this AHRP program. I'm also very thankful for the chance to meet many wonderful like-minded people here throughout the program.
Okay, so I also remember about the advice from the CEO of Malaysia HR Forum, which is Mr. Kumar. He always says about AKS, attitude, knowledge and skill.
So first job, don't berkira-kira, work hard. The first 10 years of your working life, and what I've said the other day, the first 10 to 15 years of working life, it's all about hard work. So first job, grab what you can first, take it up, build your experience, build your competencies, learn the skills that you don't have today. The time will come when something will tell you that it is time to move on.
So you have to remember that having qualification doesn't really guarantee you a job, but it can land you with one. But for you to continue climbing the ladder, it's all about skills. And when we talk about skills, of course, not just soft skill, communication, writing, but relates to what you're doing.
What happened between that time until now? I never quit, never lie, and I never want to be somebody other than myself. So if you're a boring person, be boring. If you're an animated person, make sure that animation comes out. And if you're a person that is shy, so be it. The moment you lie, the moment you say you know things and you don't, that's when you won't get the job. At that rate, by the time you are 30, you're going to be having a salary of 7,000 ringgit. Congratulations. But 7,000 doesn't cut it in KL. Learn, continuously improve yourself. This AHRP paper is one of them. Continue to add stuff in your CV.
As a HR professional for many years, the AHRP program, the quality of candidate that we see today, they are well equipped with the confidence, the knowledge and skills of HR, what is it to be a HR person, and all of them coming from other background.
I'm very thankful for Malaysia HR Forum by giving us this opportunity to interview some candidates that they have trained in a 5-day program, and they also filtered the candidates based on their own requirements. And I would say that this is a fresh batch of candidates for us to interview. So it was good, and in a couple of days we will shortlist some candidates and hopefully to organize a second interview with them.
When I first saw it, I thought it was a really good idea to bring candidates together with a specific specialization, which is why I wanted to participate, because I've got HR needs that I'm looking for. So it was a good platform for me to meet a good pool of candidates who have a certification that I can work. Some of them are meeting expectations. As an organization, I'm looking more towards the ability to communicate, looking at critical thinking, character and motivation of the people. So I think for the most part, I've met good people today.
Overall, it's a good experience to participate this HR Recruitment Day. And I think it's a very meaningful event that helps the fresh graduates out there to have the employment opportunity. Overall, I find the session very fruitful, and we managed to get a few good candidates, and we are going to shortlist for the second interview with our company.
At HRD Corp, ladies and gentlemen, we are deeply honored to be invited as a strategic partner for this conference. This conference stands as a beacon of innovation and forward thinking, set against the backdrop of a rapidly evolving digital landscape that fundamentally alters how we work, interact, and grow. These systematic shifts brought about by the COVID-19 pandemic really have underscored the indispensable role of HR in navigating these changes, making our gathering here today more critical than ever.
And we like number of people yang datang, the event.
It's a very wonderful job done. Even till now, we've been part of many events out in the West and in Europe as well.
Having all this knowledge under one roof over 2 days is really useful.
I think the organizer has been doing a great job so far. I think everything else is good. The traffic is great. Yeah, we did enjoy our time here at the event.
I actually quite salute, with how they organize the whole thing, starting from the registration, everything is quite organized, in sequence, in line. And of course, they provide even food for everyone.
A lot of familiar faces. So dia macam nak satu big reunion macam tu.
If it's on again next year, we will certainly be coming back.
Scene here in KL is outstanding, and we hope to join you guys again in the next event.
First of all, I'd like to congratulate Malaysia HR Forum for putting up this wonderful place, and all those people who behind Malaysia HR Forum. Congratulations to you. First of all, I am very privileged and honored to be here this evening. The reason I come here today because I want to give a strong endorsement that the only way forward for the country to progress and the industry to prosper is by learning development. Training centers like this is very important. They are very low cost, high impact centers. And the grants I see is very pleasant, it's very nice. It's maybe not the 5-star standard in terms of the facilities, but in terms of the services, I think I'm sure knowing Arul and the team, they will cater better and bigger than the 5-star services.
Good afternoon, everyone. I hope you all are able to see me and hear me. If yes, just give us a yes, so at least we know everything's okay and we can proceed. So all okay? Yeah. Okay, so thanks a lot. Thanks for the input. So good afternoon to all of you all listening in today. This webinar is being streamed via Facebook, LinkedIn, as well as YouTube. So today's topic that I'm going to share is on managing and safely terminating employees with medical condition. Right, this is a topic for today. So for those of you all who have just joined us, this webinar is brought to you by Malaysia HR Forum, and for the next 1.5 hours or so, I'll be sharing with you on, how do we manage employees that is unwell. The objective is not to terminate them per se, but how do we manage them, right? How do we manage employees with medical conditions? Now, before I move on, I would like to just remind the audience today that we do have a series of webinars this month, right? Starting with the first webinar today. So we have, for those of you all, if you want to learn more on many other topics, please take note that we have a webinar on March 24, which is a masterclass recap. So that is, we will be covering on various aspects of Employment Act and industrial relations, public holiday, how do we manage it, minimum wages, etc. So don't forget to miss that. We also have a minimum wage 2024 implementation webinar. That is on March 20th. There will be another webinar on Sarawak and Sabah Labour Ordinance. That is on March 13, which is next week. There will also be a webinar on managing retrenchment. How do we retrench, employees when the business is not doing well? That will be on March 12th, and today's webinar, right? So these are the webinars that is going to happen. So please do not forget to join these webinars. It is in the afternoons like today, 3 o'clock for 1.5 hours, right? To sign up, go to our Facebook community page and look for the webinar, or go to our website, go to the webinar page and sign up for these webinars. Okay, so the slides that we are sharing today will be shared in Facebook, right? Our Facebook community. So what you can do after this call, after this session, visit our Facebook community and you will be able to download these particular sites. We will not be emailing to you, but please download it. Right, so let me move on. So just a quick intro of myself. Some of you all would know me already. Some of you all could be new to the forum or probably dialing in for the first time to listen to us. My name is Arul, and I'm attached to Malaysia HR Forum. And I've been, I've had good 22 years of working experience prior to this. So today I'm in the advisory, consulting, training world. and I enjoy do what I'm doing today. So I've had good experience working for 2 large organizations with 9,000 employees back then when I was there. Managing partly with union, employees, medical issues, etc. So whatever I'm sharing today, it's very much based on experience plus compilation of cases and best practices. So that will be the topic for today. Now, I'm sure many of you would have a concern, how do I manage an employee with medical condition? I've got employee who's always on sick leave, long MCs, on and off MCs. I've got employees with kidney, failure stage 4. I've got an employee with cancer, diabetes, need to go for dialysis. And I've got employees, for the last 5 months, he or she has been on unpaid leave, long hospitalization leave. So how do we manage all this? Do we need to keep them forever? What can we do, right? So that will be discussed today. Now, before that, I would like to welcome all of you all to join our Facebook community. If you're already a member, thank you, good. I'm sure you have benefited so much. But for those of you all, if you are not yet our Facebook community member group, is a Facebook group, you can see the QR code shared in the screen, scan the QR code, join the group. And please get all your employees, your HR colleagues, your HR department, join this community as well. So in this community, we have actually crossing 50,000. This is a slightly outdated slide. Today, we are almost touching 50,000. So you can get tons of documentations. There is over 45 policy templates in the forum, various forms and documentation and guidelines, process flow, guidebooks, and various others in this community. That we discuss issues, topics, updates on what's happening out there, latest news, latest industrial court case review, what are the cases, how do we overcome this? So all these are discussed, shared for free in the forum. So please do join us. This is the community page, right? It's a Facebook group community. Now, before I begin, I would like to share this one slide. It's a slide that I commonly share, and I encourage all of you all to run through this one slide before you begin any HR presentation, right? This slide simply says that compliance, if you comply, right? Compliance, it's not expensive. Sometimes we try not to follow the law. We try to avoid because we think it's expensive. But what this slide says is, if you think compliance is expensive, try non-compliance. In other words, compliance is not expensive. Let me give you an example. Let's say it is now 10 o'clock in the morning. We want to have a quick breakfast. We park our car on the roadside, dash to the Kedai Mama to have a quick nasi lemak and teh tarik. And, took us 20 minutes and we come back to the car. Then we realize there's a summon on the windscreen. Now, we were not compliant. If we were compliant, right, the cost is 60 cents. But because we choose not to be compliant, now we end up paying 60 ringgit, 100 ringgit, 80 ringgit, whatever that your town council will charge you, right? So compliance is expensive. Sorry, why am I making a mistake? Compliance is not expensive. Non-compliance is much more expensive, right? So again, I would like to repeat. If you think compliance is expensive, try non-compliance. Okay, so let's run through this slide. I will share these slides with you later in the Facebook community. Run through this so that everybody in your organization is aware we must be compliant, right? We must follow the laws. Now, trying to save costs, trying to increase our profit cannot be in the expense of compliance, right? Compliance is compliance. If you want to increase profit, look at cost reduction in other methods. Look into reduction of waste or grow your revenue, but not taking a shortcut when it comes to the law, right? So that is a small catchphrase for today. Now, let me go through the points. So I will take about 45 minutes or so to run through these slides. Then you will have another half an hour to max about 45 minutes to ask any question answer, right? You can post your Q&A, your question in the chat box. So later part, my colleagues will pick this up and share it with me, and I will be able to address them, right? So today, let's stick to medical related topics, not anything else, not on overtime and others, right? Let's stick to medical topics so we can make the best use of our time today. Now, I would say this: our employment practices in Malaysia, right, do allow companies to terminate employees with medical conditions. So if an employee cannot work anymore because of medical conditions, we can manage them out, right? I will share this in the subsequent slides, right? If they are not well, if they are incapacitated due to medical illnesses or disability which prevents them from carrying out their job functions. However, we are expected to be, number one, we must be reasonable. Number two, we must show that we have exhausted various options and actions. Number three, we must show that we have made sufficient and necessary inquiries. We got to find out, right? And number four, we got to evaluate all surrounding circumstances. Now, I can assure you, based on past cases, if all these four criteria are met, right? If all these four conditions are met, I'm quite sure you have a good case. So number one, you got to be reasonable. Number two, you got to exhaust various options and actions, right? That means you got to look at what are the options you can take. How do we support this employee? So explore all of this until you no longer have any more options and there's nothing more else you can do, right? That's number two. Exhaust various options and actions. Number three, you got to make sufficient inquiries. You got to find out. Now, find out means not you checking out, because you and I, we are not a medical professional. We are not trained, right, to diagnose the employees' illnesses, etc. We got to do this through our panel doctor or through our appointed doctor. So number three, you are required to make sufficient and necessary inquiries. And number four, evaluate all surrounding circumstances. So these are the four things that you have to do. Now, these are some factors, right, we got to take note of when we are going to terminate an employee on medical grounds because they're not, they're not well and so on. Number one, what is the employee's nature of the illnesses that he has? What is it, what is he suffering from? Number two, what is the likely length this employee will be away during the illnesses period for them to recover, right? And would this medical, today they are slightly better, would this reoccur again? How long will he be away from work? One day he's okay, then not okay, then he's okay, then okay. How long will he be away? What is the impact of this employee's absence on the company, on the other employees, right? Now take into account all this. So these are some factors to consider. Now this is a simple funnel, which gives you an idea, how do you move forward? Now, typically, the medical issues that you hear often, number one, it can be terminal or chronic illness, cancer, diabetes, blood pressure, etc., and it becomes quite severe. Number two, is the employee met an accident at the workplace. Maybe while performing his job, he fell off the ladder or he slipped down the staircase, right? This is a workplace-related injury. Then we have got non-occupational or non-workplace injury. For example, the employee was playing football, he broke his leg, or had a motorbike or vehicle accident. So these are issues happen outside of the company's premises. Now, frequent MCs, on and off MC, or long MCs, or there could be other cases. For example, the employee has some mental health issues, right? So these are the common ones that you are familiar with. So what do you do? So these are a guideline, or shall I say, it's not really a guideline, it's not a formal guideline, but these are based on best practices, how we can do it. Now, remember I mentioned just now, there are 4 conditions that we should meet so that our case is a good case, right? Remember again, let me repeat again. Number 1, we must be reasonable. Do not rush the process, right? Don't take shortcuts. Now, the industrial court always tells us this, whether it's performance related, discipline related, medical, whatever, PIP, performance, always take a slower approach. When we terminate an employee, always take a slower approach. Now, of course, if there's a gross misconduct, there's a major misconduct, that's it. Let's say there's a theft found guilty, you can terminate them. But when it comes to medical performance, always take a slower approach. So what do we do? When an employee have any of these illnesses, we got to start doing something, right? Now, personally speaking, I'm not so concerned, or shall I say, employees with terminal or chronic illnesses or known injury, had met a motorbike accident. These are issues that we know. People don't cook up these issues. But I think what we fear most, what you and I fear most is when an employee, generally he's well, he or she is well, but on and off on MC. Yesterday was, 2 days ago was not feeling well. Sorry, he was okay. Yesterday he says, oh, I got fever, flu, etc. Today come back to work, he's perfectly okay. That's strange, right? Monday, okay, perfectly well. Tuesday fell sick. Wednesday come back to work, perfectly well. Right? So sometimes this rings a bell. Really, is this employee not feeling well, and so on. So what do we do? Right? What do we do? You have to do something. You can't just leave him or her unattended to. So the idea is this: the moment the employee exhausts their sick leave or hospitalization leave, the moment they exhaust means they finish. If they have 14 days per year of sick leave and 60 days of hospitalization leave, so the moment they exhaust this 14 or 60, you have to do something. So what do? Send them for medical assessment. You appoint your doctor, send them for medical assessment, and if necessary, counsel them. If the doctor says that employee is fit to work, you give them a simple letter, maybe a letter of advice or a counseling letter saying that, dear so-and-so, based on the doctor's assessment, you are perfectly fine. Please improve your attendance, right? Now, many of us don't do this. So we complain, oh, employee taking MC, long MC, etc. But by just sending them for a simple medical assessment and a simple letter after the assessment, that alone can help you to reduce the current issues that you have, right? So who is the doctor? You appoint the doctor. You find a doctor, you appoint the doctor, you pay for the bill, you tell the employee, dear so-and-so, please go for medical checkup. In your misconduct policy or your disciplinary policy, please put in a statement. It is compulsory, or shall I say, failure to attend medical assessment when instructed by company is a misconduct. Put it in. You tell the employee, this is something you got to do. Insubordination means what? An employee who do not follow company's instruction, that is insubordination. In one of the case, federal court says this. In the case of Niao versus Sungai Wang Plaza, the federal court says this: any reasonable and lawful order of the company must be complied. So if I want to send an employee for medical, for a medical assessment, in my view, it is reasonable, it is lawful. The employee cannot say, cannot, or I do not want to go. But if you're not paying for it, then you're giving them room to say, oh, I can't afford it. Because this kind of assessment can cost 200-300 ringgit or even more, right? Now, remember this: if end of the process, right, end of the day, after 6 months, 9 months, or whatever period that you're going to embark on, if the employee still cannot recover and you feel it is time to, look into the next stage, right? Probably medical bought them out or frustrate their contract. Now, when you want to do this, always be very sure that you're able to justify, you're able to defend, you're able to argue this case if it goes to the court. So take no chances. If you're going to terminate an employee for whatever reasons, today we are talking about medical reasons, or if it's going to be on performance, disciplinary, do not take shortcuts. If you know the case is going to go into termination, do not take shortcuts. So what do we do now? Send them for medical assessment and counsel them. So for those of you all, if you are new to this, there is a medical assessment template, a form, which you can download in the forum, right? Go and download this, this form from the forum and modify it and use it. If you want to know how to craft this sentence into your misconduct policy, again, go to the forum in Facebook, search for the misconduct policy. You will find a way we have crafted there. Failure to attend medical assessment is a misconduct. So download this policy and make use of it. There is also another policy called medical assessment policy. Go and check it out, right? These are some of the templates that could be of great use to you. So now, once the medical assessment is done, what will happen is some employees genuinely or naturally they are ill, they have not recovered, they will need to be on continued unpaid leave, because once the sick leave and hospitalization leave is exhausted, they do not have any more paid sick leave or paid hospitalization leave. So what happens? If they still need to go through recovery, they will be on unpaid leave, right? They're not getting paid, they're at home recovering. But in some cases, they are recovering. The recovery is quite encouraging, but they are not able to return to normal work, return to their original duty. So what can you do? If there's an opportunity to modify their duty, or to, if there's a light duty available, you can also provide to them, right? For whatever number of days that, until he or she recovers. So these are the two options that you have. Or there could be some scenario, the employee has fully recovered, after 14 days and after 60 days, now he's perfectly fine. He is able to go back to his original position. Or another scenario is an employee met a motorcycle accident. He broke his leg, and what the doctor has done, they have put a plate in his leg. So now he cannot perform the job of a technician because he limps, right? He limps when he walks. So he can work, but he cannot return to his normal job or normal duty. So what do? We put him on a permanent modified or permanent light duty, if you have, and if he can do it, right? I know there are also organizations out there, right? They can afford it. They pay a lot of attention to employees' welfare. They also have prolonged illness. Prolonged illness means, a prolonged illness benefit. In other words, once they've exhausted their hospitalization leave and their sick leave, if they still cannot recover from the illness, they are given, a period of, this is a benefit, for a period where they are paid salary. They're given a salary, but they can't work. So they're given this prolonged leave allowance. So what happens here? So once I've exhausted my sick leave and hospitalization leave, the company voluntarily, the law do not require to provide one, but if you want to do it, you can afford it, you can go for it. For example, the prolonged illness leave that we commonly have out there, 3 months of full pay, 3 months of half pay, 3 months of no pay. They're not working, but they still get pay. Some organizations I've seen 6 months full pay, 6 months half pay. I've even seen cases where it is just 3 months full pay and that's it. No half pay, there's no pay period, right? So if you have it, you are able to provide it, good, fantastic. Now, some of these employees may also qualify for SOCSO rehabilitation. So if they qualify, send them for rehabilitation. It'll be, it is advisable. I would say it is highly encouraged to pay them salary during that period, right? They're not working, but encourage them, because they're not working, they are medically unwell. Sometimes, they don't cook up this thing. Met an accident, nobody asked for an accident, right? You can show, you can show compassion by supporting them, right? Send them for SOCSO rehab. If you have prolonged illness, and they qualify, give it to them. And after this, what do? You send them, maybe after prolonged illness leave, they are not able to recover. Therefore, they still need to continue to rest at home, to recover. Or recovery is good, but not fully recovered, they can go into modified duty or light duty. If you have it, provide it to them. Now, again, send them for another assessment, right? Send them for another assessment, and if necessary, counsel them, right? And finally, after doing the so-called the last assessment, they are perfectly fine now, but they cannot resume normal work. So permanent duty or light duty if you have it. Or they can go back to original position. They're fully recovered. So go back to original position. Or if they cannot perform light duty, they cannot go back to the original position. So what do? You now have to frustrate the contract. Or if they've got a SOCSO payout, you bought them out, right? That's it. So these are the end stage. Now, from the start to the end, I can tell you, it may take even up to a year, right? Not 2 months, not 3 months, because medical recovery doesn't happen instantaneously. It may take some time. So a reasonable period, in my opinion, would be 1 year. So if you have an employee, put them on, so-called this medical process, and, let them through for a year, At end of 1 year, end of 12 months, you got to decide, right? Are they able to go back to their normal duty, or can we assign them to some modified duty or light duty, or we frustrate their contract, right? These are the three options. But do not leave things hanging. The problem with us is this: an employee is not well, we just left it. After 1 year, suddenly HR woke up. Suddenly the company woke up. Hey, I got this employee for last 1 year. Why do you wait for 1 year? The moment, I hope all of you all take, if you have a piece of, a paper next to you, write this down. The moment any employees exhaust their sick leave or hospitalization leave, start the process. Not wait for 6 months, 1 year, 2 years. I've heard so many cases. Oh, I've got this employee, Arul, I would like to get your advice. What is it? I've got this employee for the last 12 months, last 18 months. Why do you allow 12, 18 months to pass by? What was HR doing? Was HR sleeping? Right? The moment the employee exhausts their sick leave and hospitalization leave or hospitalization leave, start the process. Now, let me just share with you a couple of cases from, past cases, which I think will help to, to understand better how do we manage cases like this. Now, I'm not going to read through line by line. You'll have the slides later. I'm just going to, highlight some of the points that you can see in black and bold. Now, in the case of MHS Aviation versus Zainul Akmal, the court says this, the court says the termination is unfair. Why? Because the company had not made any inquiries on the illnesses. They never do a proper assessment, right? You must inquire. Now, when I say inquire, it does not mean, hey, Fahmi, what's the issue? Not like that. We got to send the employee for a proper medical assessment, let the doctor assess, and let the doctor give us his expert opinion as a medical practitioner. So in this case, the termination was unfair, and the court says this, the company had not made necessary inquiries, and the termination was made, was based on assumption that the illness is going to be or is permanent. Assumption. Now, this is not buying some lottery ticket, we make a gamble. No. We've got to be very objective in managing this kind of cases, right? So we got to inquire. Now, in the second case at the bottom, Gopala Krishnan versus Goodyear, this claimant, this employee, he suffered from a recurring knee injury. That means the knee injury, was ongoing. He was terminated on medical grounds despite working for the company for 11 years. And what happened in this case, the judge says, now, when we medical bought out, when we terminate an employee on medical conditions, right, we must be reasonable, right? We must be reasonable. And there is an obligation, right? There's an obligation. We are the employer. So we must have some social consciousness, not just simply terminate them. The court says this, the company should attempt to offer an alternative employment to the employee, even though it may be a lower paying job. So let me give you an example. A technician earning 4,000 ringgit met an accident, and because of the accident, he's got a plate, put in his leg, and he can't walk like usual. He cannot climb the ladder. He cannot carry heavy stuff, heavy equipment. So he cannot perform. He is no longer able to perform the job of a technician. But we have a job as a storekeeper. Current salary 4,000, storekeeper 3,000. So what do? You offer this job to the technician. Now this job don't require you to carry, don't require you to lift any heavy items, no need to climb. It's a desk and chair job. Your job is to record all the inventory in, inventory out, or product in, product whatever, right? So offer it to him. So this is what this is what is meant as company should attempt to offer an alternative employment to the employee, even though it may be a lower paying job. Now, frustration of contract. So I'm just going to read it briefly, not to bore you down with legal jargons. So frustration of contract, some of you all may, you may have heard this, you're familiar with this, but for those of you all, if you're hearing this for the very first time, now frustration of contract, it is not a terminology from Employment Act, but it is under the Contracts Act. So the Contracts Act govern all the contracts in Malaysia. So Section 57(2) of the Contracts Act says this. Now, in any contract, there's always two parties, right? The buyer, the seller, the employee, the employer. So there's two parties. Now, what happens when either of the party, either one of them, they cannot fulfill the contract anymore for reasons beyond their control, right? So now, for example, in the case that we are speaking today, an employee and employer, the employee became ill. Now, he didn't ask for illnesses. It is not a misconduct. He became ill. He cannot fulfill the contract anymore. He cannot come to work because the contract says what? You must come to work every day, Mondays to Fridays. You got to do this. If you do this, I pay you X amount of money as salary, right? There's an agreement. So now this employee, what is his obligation? You come to work Mondays to Fridays, 9 to 6. You work, you get the job done. Now, what is the company's obligation? You do the job, I pay you salary of whatever that we agreed. So both of them, they've got obligation. But now in this case, the employee cannot work anymore beyond his control. So in this scenario, it is considered that the contract is frustrated, right? So this is what we call as frustration of contract. It becomes void when the employee or whoever the person is or whoever the party is, they cannot, carry out the contract obligations anymore. Okay, so that is frustration of contract. So please read. So frustration happens when an employee die, right? Employee do not apply, I want to resign from the job because of, right? So when employee dies, prolonged illnesses, or they become incapacitated, they cannot work anymore because of illnesses. So these are some circumstances where the contract may have been deemed to be frustrated. Now, if you now terminate an employee on medical grounds, right? Now let's put the terminology aside. Sometimes we get a little bit confused on the terminology. Should I use medical bought out? Should I use frustration of contract? Should I use termination of medical ban? These are three common ones. Frustration of contract, medical bought out, termination of employee on medical grounds. So let's put the jargons aside, right? Let's put this aside. Now, whether you terminate medical bought out, end of the day, there is a separation taking place on medical reasons. Now, if this happens, right, you remove the employee because of medical reasons, can the employee file a case at the industrial court, for example, that I feel this decision by the company is unfair to me? Yes, he can do that, right? Under Section 20, the employee can file a case. Now, if you look at the second item in bold, right? So the item at the bottom, this is a UK case, Garrix versus Nolan. The court also says this, that employers cannot be expected to go to unreasonable length to accommodate an employee who is not able to carry out his job, to the full extent. So if an employee is not well and he cannot perform his job to what he's supposed to do, how long should you wait? 1 day, 1 week, 1 month, 1 year, 10 years, right? Can the company wait for 10 years? How long should the company wait? Now, the court, normally they don't suggest how long. You got to decide. That is why, the first slide, it says that, I mentioned there, you got to be reasonable, right? If it's a basic illness, fever, flu, cough, headache, 1 or 2 days, done. If an employee, has, let's say, urine infection, 1, 2, 3 days, done, right? Cough, 2, 3 days, or maybe a week, done. But if employee has something severe, right, the process can take much longer. Accident recovery can take a long period at times. But there are also some cases, if the person has cancer, stage 1, stage 2, stage 3, recovery is going to be impossible. But again, how long can you wait, right? Now, malingering, this is your common issue. Malingering means what? The employee he's well. He's not, he's quite okay. He's not sick, right? He's well. He's not unwell, right? He's not sick. But he pretend to be sick in order to avoid work. So 2 things. Number 1, if an employee is sick and he gets an MC, whether it's 1 day, 2 days, frequent, that is not a misconduct, right? If he falls sick, every now and then MC, that is not a misconduct. If he is genuinely ill, if the employee is genuinely ill, he gets MC, not able to come to work, that is not a misconduct. But not coming to work, pretending to be sick, and they got an MC, that is a misconduct. So you got to able to differentiate these two. So if an employee feign means he faked, right? He faked his sickness in order not to come to work. He's actually perfectly well. But you see the doctor, he put on a drama, and doctor says, oh, you know what, your condition is so bad. I tell you what, I give you 1 day rest, MC at home. MC, you rest at home. Now, is the doctor wrong here? Because the doctor has listened to his declaration, right? So if an employee malingers, that is a misconduct. If an employee submit false MC, tempered MC, or forged MC, that is also a misconduct. Now, let me give you an example. Sometimes we blame the doctor. We say, no, this doctor. Now, it's not the doctor's fault at times. For example, an employee, morning he woke up, alamak, 10 o'clock. If I go to work, my boss is going to, my boss will scold me. So what he does, he wears some ugly looking shirt, shabby, never comb hair, never bathe, mandi minyak cat kapak, smell. He go and see the doctor and say, doctor, malam tadi doctor, saya ceri berit 10 kali doctor, tak boleh tahan. Doctor said, oh, your condition looks so bad. Now, the doctor is not going to tell him, oh, macam tu ke? I tell you what, why not you sit here in the clinic? I want to see how many times you go toilet. Doctor will not do that. Based on the employee's declaration, the doctor is going to say, yeah, your condition is so weak, you look so weak, I give you 1 day off, right? 1 day MC. That's what doctor will do. Now, not every illnesses can be tested. Fever, yeah, you put a thermometer, you will know the guy has a fever. Flu, yeah, you can see, mucus dropping. What about headache? How do you gauge headache? You say, doctor, last night I got migraine. How do you gauge migraine? How do you test migraine? Backache. How do you test backache? Diarrhea. How do you test diarrhea? So there are some issues that cannot be tested. Doctor will rely on the employee's declaration. So if the employee do not want to go to work, he can put on a drama to convince the doctor, I'm not feeling well. But in fact, he was feeling well. Now that is called malingering. Now in the case at the bottom, in the case of Regent Kuala Lumpur versus Gerard, now the industrial court said this, he was malingering. He was well, but he claimed he's unwell. He took medical leave. But then later part of the day, he attended the family day function in the hotel. If you're not well, shouldn't you be resting at home? What are you doing attending family day? Right? That's malingering. Now, the other one is excessive MC, right? They take too many MCs. Now, again, taking MC, it is not a misconduct. Taking excessive MC, it is not a misconduct. But taking MC to avoid work is a misconduct. Taking excessive MC to avoid work is a misconduct. So, two different things. Taking MC because they are genuinely ill. They are really ill. That's not a misconduct. Too many MCs, but they are genuinely ill. That is not a misconduct. But taking one MC or multiple MC or too many MCs, but to avoid work, that is a misconduct. So here is a concern. But the bigger concern is when employees, they are feeling well, they're actually okay, but they pretend to be sick. Right? People who are genuinely ill, we support them, we care for them. But people who abuse, you got to monitor them. You got to take action on them. Right? This is what the case of Malayan Smelting say. So taking excessive MC in order not to come to work is a misconduct. Now, if you look at this particular case, in 1979, 49 days of MC, the following year, 32 days. In the same year, later part, another 7 days, right? So now, the company has sent him for medical assessment. You can see there, considering the claimant, he had been certified physically and mentally fit, right? And he was not able to produce any other evidence to show that his health has gone from bad to worse. He cannot produce this. So remember this, I always tell this to my clients. Now, if an employee is not feeling well, you find something is wrong, the burden is not on you. Put the burden back on the employee. You tell him that, hey, dear Lim, Lim, I want you to go and see Dr. John, our panel doctor. Dr. John is going to assess your condition and advise the company whether you're fit or not. Now, I would encourage you to bring all your medical documents to go and see our panel doctor. Right? He will assess you. You bring the documents, not for me to prove that you're not well. So remember this, it is not your burden, HR, remember this, not your burden to prove whether he is well or unwell. You tell the employee, you bring the documentation, right? You got to prove that they're not feeling well. Throw it back to them, right? So now in this case, he could not produce any any evidence that his health has gone from bad to worse, etc. The company terminated him, right? So this is a case of Dunlop versus Dunlop, the union of Dunlop against the company. Now, this is another case in Clangport, right, versus Carpia. 1994, 35 days, 47 days. Then the following year, 48 days. Then the following year, 51 days. So again, in this case, you see this. He was subjected to a counseling session. That means the company has put him into a counseling session for his medical history. And he claimed, right, he says that he had a gastric issue and he was operated, right? There's operated on his stomach. I mean, there's operation made to his stomach, which caused his medical problems. He underwent, that means the company sent him for a compulsory test, right? Compulsory medical test. And after the test, doctors say he's fit, right, for normal duty. He was given final warning. Doctor says he's fit. He was given final warning. He was reminded to change his attitude and improve his performance, right? Improve attendance. And because there's no improvement, he was suspended and subsequently dismissed. And the industrial court says this: any employer, right, if you're not feeling well, fall sick, we understand. The court also understand. Company should understand, right? But malingering, pretending to be sick to avoid work is an abuse. That is a misconduct, right? So that happened in the case of Clangport. So now, how do you spot employee abusing medical leave? One day, I mean, before holiday absent, after public holiday absent, Mondays, Fridays, after payday. If it happens one time, we can't spot it. But if it's a trend, right? You see this as a trend. On and off happens. What do? Send for medical assessment, right? So very simple. Let me just throw a couple of ideas or suggestions. If you have an employee today, always on sick leave, send him for counseling. I mean, send him for medical assessment. Appoint a doctor. I would always encourage a physician if possible, specialist. Appoint a doctor, send him for assessment, right? That's number one. Number two, if assessment done, doctor says fit, confine their clinic. You tell them, Lim, starting tomorrow, you can only go to this particular clinic. We are not going to accept any other MCs from any other clinic. We are paying for it. You go to this clinic, right? You do that. So what you do is you confine, so he now cannot go to multiple clinics anymore to get his to get his MC or to get his treatment. So the moment you see someone having excessive MC, send for assessment. That alone, you will see some improvement in your employees' behavior, right? But we don't do that. So sometimes when I advise the company, they say, alamak, it's going to cost us money. It's going to cost you more money if you don't manage the issue. I would rather spend the 300-400 to resolve this issue than not spending money at all, right? Sometimes when there's a problem, what to do? You got to spend money. Like your car. You drive a car, right? If your engine has an issue, you got to spend money to rectify the issue. Or you're going to continue driving the car. If you continue driving the car that has got issues and you don't rectify it, the car one day is going to break down. It's going to cost you much more money. Same goes to employee. If an employee has got medical issues, right, send for the assessment, spend that 200-300, because if you don't do that, if there's a major breakdown, you spend even more money, right? So do that. Now, before I go to Q&A, I just want to touch on maternity protection. It's just a small additional topic. Some of you all may not be aware on some of the conditions of medical protection, medical benefits. So let me just run through very briefly. Now, the Employment Act, the amendment that has happened in 2 years back, allows employees to go on 98 days, right? 98 days. Now, any employee, any female employee, condition married, not married, the law is silent. So you cannot put a condition in your company policy, must be married. The law says, the law is silent. So even if you have a female employee not married, deliver a child, she is entitled to medical benefits. Maternity benefits. Or a foreign female employee, let's say from Indonesia, she's pregnant. She is also eligible for maternity benefits. You cannot say foreign female worker cannot. The law says they can. So remember this, whether they are married or not is none of your business. A foreign employee, a foreign worker is also eligible for maternity benefit. EA applies to all, local, foreign. So if a female employee is pregnant, she delivers a child, she got 90 days of maternity leave and up to 5 living child, only 5. If she delivers child number 6, answer is no. They still go on leave, but no maternity payment, right? So it becomes like unpaid leave or unpaid maternity. Now, there's 2 conditions that the employee must fulfill in order to enjoy the maternity allowance. Number 1, they must have worked 90 days in the last 9 months, right? So the last 9 months before they deliver, because employee is pregnant for 9 months, right? So for the last 9 months, they must have worked for you for minimum 90 days. And in the last 4 months before their confinement, before they deliver the child, they must have worked for you anytime, at least 1 day in the last 4 months. So these 2 conditions is 2. That means it's this A and B, right? Condition 1 and condition 2. Not all. Both conditions must be met. So let me give you a small trivia, right? So you look at this scenario, right? Look at this scenario. Scenario number 1, right? Maybe you guys can help me out, right? See whether they answer yes or no. So scenario number 1, right? Okay, just for ease of discussion, ease of illustration, every month, let's consider 30 days. Whether month 1, 2, 3, 4, every month is 30 days. So remember 2 conditions. The first condition is that they must have worked 90 days in the last 9 months. The second condition, they must have worked any time in the last 4 months. So first scenario, do they qualify or not? Yes or no? Right? First scenario, do they qualify? Anybody answered yes? Right? The first scenario, did they work 90 days? Yes, you can see 30, 60, 90. And in the last 4 months, from month number 6 to number 9, they work more than 1 day. So do they qualify? Answer is yes. Scenario number 2, did they work 90 days? They work full. They work entire 9 months. So condition 1 is met. Condition number 2, did they work any time in the last 4 months? Yes, they work month number 6, number 7. So yes, even though they are no longer working, they have qualified for maternity allowance. Scenario number 3, did they work 90 days? Yes. Did they work any time in the last 4 months? No. Right? Did they work any time last 4 months? Yes. Because month number 6 is the, month number 6, number 7, number 8, number 9. So month number 6, they work. So scenario 3, they also qualify for maternity allowance, even though they have resigned and gone. They qualify. They can come back to you and demand for, and ask for their maternity allowance, right? Because they've already qualified. Scenario number 4, did they work in the last 90 days and the last 9 months? Yes. You can see they work for 3 months, 30, 60, 90. Did they work anytime in the last 4 months? Yes. They work in month number 7, number 8, number 9. They qualify. Now let's look at scenario number 5. Did they work 90 days in the last 9 months? Answer is yes. Month number 1, number 2, number 3, more than 90 days. So scenario number 5, they work more than 90 days. Did they work any time in the last 4 months? Answer is no. Why? Because month number 6, number 7, number 8, number 9, in the last 4 months, they did not work. Therefore, they don't qualify. But if I move the bar a little bit, right? If I move the bar, I extend the bar, that means they resign in the 6th month, first week. That means they work 1 month, they work 1 week in the month number 6. Then they qualify. Because why? In the last 4 months, they have worked for 1 week. Right? Some of you all may find it a bit confusing, but these are some ideas, to take note of. Now, these are some basic understanding. As long as a female employee was, completed a pregnancy for 22 weeks, that means usually a full pregnancy is 36 weeks, right? 9 months is 36 weeks. But if they complete 22 weeks, and after week 22, maybe miscarriage or premature birth, or the child died, right? They still qualify for maternity. The husband will qualify for paternity, right? As long as after 22 weeks, she delivers a child, whether the child is alive or dead, she qualifies for maternity. The husband qualifies for paternity, right? And up to 5 living child. So foreign workers, they enjoy it. Whether they are married or not married is none of your business, right? Because the law did not say must be married. But for paternity, if you recall again, for paternity, the husband must be married. But for maternity, the law did not say must be married or otherwise. Foreign employees, let's say if it's an operator from Indonesia, they got pregnant, they are eligible for it. You cannot say cannot, right? Immigration. That's immigration business. But for employer, as far as Employment Act is concerned, they are eligible for maternity allowance. Okay, so now roughly that's it. So it is now 3:40. I'm going to take on your questions, but just before you go, I would like to encourage all of you all, if you find this session is useful, I would encourage you to join our masterclass, right? A small advertisement. No free lunch in the world, right? You'll be thinking, hey, how come there's no free lunch? So, right. So join our masterclass program. So it is a 2-day program. I do it, I'm the trainer. So in 2 days, we will cover a whole range of things on EA and IR. How do you set up PIP? How do you terminate employees on PIP? How do you, these medical issues, we discuss in detail, maternity. How do we simplify our work processes? How do we simplify show cause letter? How do we design a performance management system? What are the amendments to the Employment Act? How do we work fast? How do we reduce our workload? And so many other things, right? So 2 days power pack training. Do join us, and of course, if you join, you get 3 months of free guidance, through WhatsApp, as well as you get, over 140 HR templates, documentations, guidebooks. All these are given, right? It's fully HRF claimable. If you're interested, do send us an email, sophie@malaysiahrforum.com. Now, at the same time, if you're a HR practitioner, we do have, a series of HR certification programs for you to attend, for you to learn up and, and upskill yourself. So we have a certification program, and all these are HRF claimable. It's not cheap, right? It's not cheap. So, but it is useful. It helps you to become better and upskill yourself, right? Enhance your credentials. So we have a certified training needs assessor, CTNA for L&D professionals, certified strategic human resource manager, certified payroll professional, certified com and ben, right? Com and ben professional, certified human resource professional for the junior ones, certified HR business partner, certified industrial relations practitioner, professional, last but not least, certified recruitment professional. So a recruiter, do join a 3-day, 3-module program and become a certified recruitment professional. So these are some of our certification programs and the masterclass just now. So right, that's small advertisement. Now it is good to invest, upskill yourself, so that if you have HR issues, any of these issues, or your company want to go for restructuring, enhance employees' capability, etc., these programs will help you to better manage your job. Okay, so let me take on some Q&A, right? So let me take on some Q&A. Okay, now I won't be able, I think there's a lot of question answers from all the 3 platforms. I will not be able to answer all, but I'm going to answer as many as I can within the topic of medical process management, right? How do you manage employees with medical conditions? Wow, a lot of questions. Okay, I'll try my level best to answer as many as I can until 4:30, right? So again, I would, if you want the slides that we have presented today, we are going to share it in Facebook community. Go to the community page and download them. Okay, so that's a presentation slide. Get it from the Facebook community. So you can also download the sample medical assessment form, the sample policy, and the slides as well. And of course, there are tons of other documentations. Okay, so let me answer questions one by one, but please forgive me if I can't answer all questions because we only have roughly 35 minutes from now. So Vinny asked these questions. In some cases, employee took MC every 2 weeks or every week, and they accumulated 8 to 10 days within 2 months. Is it considered reasonable to send off assessment? Yes, because why is an employee falling sick so frequently? Right? You are concerned. I'm concerned. You are concerned. So you tell the employee, dear Winnie, you've been falling sick so frequent. You've taken almost 10 days in the last 2 weeks, last 2 months. The company is concerned. The company will require you to go to a panel doctor for the doctor to assess your condition. Right? So please bring whatever documentations you have, you go. Now, you can do that. That is why in your company policy, please make all these conditions clear. During induction, tell them one of the conditions in this company is that if the company finds that your which you all don't do, tell them during the induction. Right? During induction, we just do induction, chin-chai. Now, induction process is not just come, happy-go-lucky, clap, welcome, etc. No. Lay down explain to them what are the company's conditions, terms, policies, and so on. So just imagine if during induction, during orientation, you tell employees, okay, guys, after you present on company intro, whatever, etc., mission, vision. Now, we like to share with you on our company, medical process. We provide insurance, etc. Now, company can also instruct you to go for medical assessment when we feel there's a need. And you got to go. If you don't go, it's a misconduct, insubordination. Right? So share some scenarios. These are some scenarios we can send you for assessment. When there's so many MCs, suddenly in 2 months, 10 days, 12 days, we may send you for assessment. Not because we want to take action on you, but we want to know, we want our doctor to advise us whether you're fit or not fit. Share this upfront, which we all don't do, right? Okay, after exhaust hospitalization leave or sick leave, after the employee, Catherine asked this, after exhaust hospitalization leave, they will continue annual leave. Can we proceed annual leave before unpaid leave? Yes, naturally, they have got annual leave, right? So annual leave. But some employees, they may want to preserve their annual leave, right? They may want to preserve the annual leave because maybe for Chinese New Year or Raya, Deepavali, etc., they say, can I take unpaid leave? So what do? In your employment policy, right? Spell this condition out. If you have exhausted medical leave, you are obliged to use your annual leave. Spell it out. The problem is we don't spell it out. When we have issues, macam mana, how? Then you start calling around. So spell this out in your terms of employment. Right, Catherine, that's for you. Okay, next question. Okay, so Sarah asked this. I have a question. How appropriate is it for HR to verify the authenticity of employee sick leave by contacting clinic? Yes, a lot of companies do that. I know recently there was a viral video, where company call and check, and they said, no, company don't trust, etc. I don't think it's an issue of trust here, right? It's not a matter of trust. Now, I've been an employee as well. I've also fallen sick, but there wasn't any requirement. There's no need for company to call because my number of sick leave is not many, right? There's no harm for employees to verify. If you have nothing to hide, why you worry? Right? Tell this to employee. If you are genuinely ill, we want to support you. But we notice that you have got so many MCs. We want to know why. Right? So send them for assessment. So if you feel there's something wrong, there's nothing wrong to call. So during induction, I would tell all of you all this. Now, in your induction slide, do this today if you can, or tomorrow. Write it down as a list of action item to do. In your induction slide, mention all this. Under your disciplinary process, medical process, I'm sure you brief your employee disciplinary process, right? Also explain a medical process that the company requires employee to attend medical examination when, number one, frequent sick leave, or there's too many sick leave. the company can also, verify the authenticity of your medical certificate. Now, remember, there's so many cases went to the court. Why? Submitting false MC. So how do we ascertain? How do I know the MC that you submitted is false or not? I can only do that by checking. Am I right? So employee cannot say why you cannot check. It is not illegal for company to call the clinic and check, right? If you don't check, you won't know. So to me, there's nothing wrong. And companies do that, right? Again, you must tell employee, it is not a matter of trust or don't trust, right? It's not a matter of trust or don't trust. Similarly, all of you all, you guys are employee, right? If the payday is on the 7th, I'm sure some of you all open up your, your banking app, whether gaji sudah masuk. Why don't you also trust the company, right? So see, trust works both ways. So you tell the employee, the company may check the authenticity of your, of your MC from time to time. Inform them ahead of time so that they're not surprised when you do that. Sometimes when you tell them, right, they know this, they can be, they'll take a more careful approach, meaning that they will try not to do it. Okay, so so Rizwan asked this question. Employee was terminated under medical board out after 3 assessments with the hospital doctor. Mentioned the employee is unfit. The employee do his own assessment with other doctors and the doctors say he's fit. What is the best advice? My thing is, Rizwan, you are not taking charge of the whole process. Appoint your doctor. Tell the employee to go to your doctor. Now remember this, in Employment Act, if you read the medical clause in Employment Act, the sick leave clause says what? An employee shall be examined at the expense of the employer at the employer chosen medical practitioner. So in other words, you choose the medical practitioner, you tell the employee, you go and see Dr. John. But if you allow them to go and see their doctor, etc., you have no control. If you want to manage these issues well, you appoint the doctor, you dictate the process. Next. Now, is it compulsory for employee to provide panel clinic? Now, it is highly advisable because when you provide panel clinic, you are in control. They cannot go mana-mana. They have to go to only your panel doctor. But if you want to keep your life easy or no need panel doctor, then be prepared, employee go everywhere. So if employee go clinic A, clinic B, they go around shopping for MCs. They go and shopping for MCs. What can you do? Because you never control things. So if you want to have a more organized approach, control them. But again, I agree. Sometimes it's not easy to do because small company, they don't have resources. I agree. So what do you do? First stage, okay, never mind. You can go anywhere you want. But second, if we find there's an abuse, we will fix you at one clinic. You can also do that, right? Now, some of you all may or may not be aware. Again, the sick leave provision says what? An employee shall be examined at the expense of the employer at the employer chosen medical practitioner. In other words, the examination costs you got to pay according to EA. So when employee goes to the sick clinic, right, they get an MC, they pay 60 ringgit. Now there's two elements there. One is consultation. Of course, consultation we know normally is 5, 10, 15 ringgit. The medication, the cost of medication is high. EA says that you must pay for examination. Medication is up to them. So if you are going to limit medication, for example, you say that, okay, annually, your annual medical benefit is only 200 ringgit. Can you do that? You can't. Why? You cannot cap consultation. You can cap medication, but not consultation. If you cap your entire medical benefits, for example, 200 ringgit per year, you are wrong. Employee can go to labor and complain against you, right? So you can cap consultation, you can cap medication, but you cannot put a limit to consultation. So take note of that. Okay, Miza asked this question. Can we appoint any certified doctor? Let me see. Can we appoint any certified doctor? For example, employee is diagnosed with cancer, already exhausted his hospitalization leave, NMC. Do we need to send to an oncology? Okay, fantastic question. So Miza, of course, you can't be sending them to various doctors, right? So that is why I suggested just now, appoint a specialist, a physician if possible, or a OHD. You get the doctor to do what is necessary to determine whether this employee is well or unwell, right? So I know of companies, they use OHD, right? They use OHD appointed by the company. So the OHD doctor will engage the other doctor, right? The other doctor to ask, okay, what is the employee's condition, etc. Then the OHD doctor advises you, right? That is a better approach. Now, you don't need to go and appoint different doctor to give an assessment, right? It is not practical. It can be very costly, and it takes too much of headache and time. Okay, there's another question above. Okay, so Emmeline asked this question: can the company deduct medical employee benefits when sending them to a medical practitioner or medical assessment? You can, but again, I would encourage you not to, right? You can, but I would encourage not to. Why? Because number one, they may have already incurred heavy bill. They may have already exhausted. So what if they have already exhausted your medical benefits? If you say that, you know, it's 500 per year, exhaust 500 per year, right? But remember, I said this, if this is going to go into a termination, please be careful. Don't save money, right? If you want to save money, then I would say this is a costly saving, penny wise, pound foolish. Now remember, if this case goes to the court and you're not able to justify why you terminated them, the employee's payout can be 24 months plus, right? So be careful. Don't try to save this kind of money, right? Anyway, it's not going to cost you $1 million. At the max, 300-400 per assessment. My framework is 4 assessment a year, 3 months, 3 months, 3 months, 3 months, then decide, right? So if 4 assessment times 300 or 400, that is 1,006. Try not to save this 1,006. Okay, if a technician in a chemical plant has undergone a heart procedure and is only fit for light duties, but there's no such rules, right? Considering cost of hiring contract staff to cover duty, how can frustration be applied? Now, again, when I look at past cases, right, the courts did not tell us that you must keep them only if you have a lighter role, only if you have, or if you're able to create one. But if you don't have it and there's no job that you can create, answer is that's it. It stops there. Okay. Again, here it is not for employee to accept or not to accept. You have to tell the employee your condition. You cannot work as a technician anymore because your current role requires you to climb up and down, carry. You got to carry equipments, but you can't. But we have a role as a storekeeper. Unfortunately, the position is lower grade, salary 3,000 ringgit, you're earning 4. So we like to offer this job to you. If the employee said, no, I don't want, then frustrate. But document all this, right? Document all this. Okay, so Irene asked this. What if employee refused to provide document from the doctor, but saying that I've confirmed with the doctor that is a regular clinic, no letter, no reports. To me, again, Irene, very simple. In your company policy, they must go and see your doctor, not his doctor. So I believe you don't have a panel doctor. So please appoint a panel specialist, right? Or an OHD, send the employee to them and tell the employee, if you don't go, that's a misconduct, right? Spell this out in your policy and, in your employment terms, and run through these slides during induction. During induction, you tell them, etc. So they cannot say, I don't know, and so on, right? Better still, right? It's strange, right? It's funny, but I tell you, it exists. There is a company out there, I just can't say the name to you. There is a company out there, in their job application form, right? In the application form, one of the items they got to tick yes or no is that, do you agree, right? Do you agree to go for medical assessment at the company's chosen medical practitioner when instructed by company? In the employment letter itself, in the application form, they say yes. Once they say yes, later part, they cannot say cannot. You can even do that, right? If the employee in the application form, if they say, do you agree to go for medical assessment when company instruct you to go? If they say no, don't hire them. That means there's something there. Don't hire them, right? So come on, HR, you guys are degree holders, diploma, degree, masters, PhD, and whatnot. Be smart. You got to take control of the situation. Be one step smarter than your employees, right? These are some small tricks you can do. So there's another question by, let me go to Lee Chia Bin's question. A staff has been taking unpaid leave for 2 months after getting to know pregnant for 4 weeks. Come back over 1 week, continue to be on leave without limit. Now, Lee, simple, medical assessment, right, guys? Majority of your questions here, right, I'm seeing the next one as well. Majority of your questions here, medical assessment. The employee cannot say, I'm pregnant, I don't want to go. Medical assessment, right? Do that first. You'll find that the moment you find there's an abuse, things are getting out of control, medical assessment. If the doctor says fit, counsel them, give them a letter. Still cannot, round 2, show cause letter, warning letter, round 3. So do that, right? But again, please take a slower approach if you're going to remove an employee because of medical reasons. Okay, so Sweeney, what if pregnant but not married? Yes, because remember, Sweeney, the law says what? The law did not say must be pregnant. You are not a moral police, right? It is not your job. Hey, you kawin ke tak kawin? No, it's not your job. As long as they're pregnant, they deliver a child, you got to give it to them, right? Because the law did not say must be married. The law is silent. In other words, you got to give to a local employee who's not married, pregnant, deliver, or a foreign worker, a female foreign worker or female expatriate who's not married but deliver a child. You got to give, right? You cannot put a condition, you must be married or not. You're not a moral police. Okay, what if employer gave alternative job to the lower staff based on the condition rejected? Simple. If reject, no more work. Document it, frustrate his contract. If he goes to the court, show the court, we have done what we could. We have even offered a lower paying job, but he refused to accept. There's nothing much we can do, but we have to frustrate. Okay, see you. That's an interesting question. Any more physical masterclass in Penang? When we come to Penang, you guys don't come, right? We go all the way to Penang, the response is low. Go to Johor, response is low. So we decided no more doing in Penang and Johor. You want to come to PJ, we have a nice academy here, right? Come to PJ and do the class, but we also have online class, right? Last time we tried a couple of times to do in Penang, response is poor. So we may not do in Penang, we'll try, but there's no guarantee. But PJ, right, in our academy, every 2 months once we do it. Okay, can employer require an employee to seek medical treatment at a government clinic if they're unwell? Yes, you can, of course. You can, they can go to government clinic, right? They can go to government clinic, MC issued by government. There's nothing wrong. Many are doing it. If you don't want to pay, you can send them to a medical clinic. But remember again, this EA says what? An employee shall be examined at the expense of the employer at the chosen employer clinic. Now, if you're going to assign them, you say, no, you must go to Dr. John. Then you got to pay for the consultation, right? But if you say that, number, you can go to government clinic, many are doing it, right? So there's nothing wrong there. Can we confine clinic to only one? Can we confine from, this is a question from Coco Crunch. I think they ate too much of Coco Crunch, they became unwell. So can we confine clinic to only one employee, right? In the event company doesn't have a panel clinic? Yes, you can, but you got to be reasonable. If the employee is staying in, let's say, Bangsa, right, in KL Bangsa, your panel clinic should be somewhere reasonable for him to travel, right? So you cannot put a panel clinic all the way in Cheras. Unfair, because why? Every time I'm sick, let's say today I wake up morning, I'm not feeling well. Now, because the company clinic is in Cheras, from Bangsa to Cheras can take 40 minutes. If it's terrible jam, maybe an hour, you cannot be asking me to travel 1 hour to clinic and come back 1 hour to rest at home, right? So you want to appoint a panel clinic, be reasonable, choose a clinic that is practically within a practical limit, right, to the employee's residence. Okay, so Nizam, malingering. Let's say we have identified a staff and confined to one clinic, but there's no improvement. He still use up all his sick leave. We send for assessment. The report says he's fit. Is it okay for the company to decide take disciplinary action on them? Yes, you can, but just be careful, because why? You say malingering, he goes to the clinic for assessment, doctor says fit, right? You confine, still no improvement, it still continues. Now, so what do we do? See, remember, go back to the past cases I shared. If there's no improvement, take disciplinary action on them, right? But again, you may be taking some chances, because if this goes to the court will be wondering, why did you terminate this guy? Doctor says he's fit. And that's why doctor says fit, but always. So the process for you may take a little bit longer. But remember this, if an employee is, let's say if I read what you're trying to say here, the employee could be playing truant, meaning the employee is just playing games with you. So what do? Medical process is not the only way to manage them out. What about disciplinary? What about performance? Right? So for me, I am very tactical. If A cannot, I'll try B. Right? I know you may say it's not fair, etc. But let me tell you this: an employee who's always on absent, always not coming to work, he would have disciplinary issues as well. Coming late, going back early, or whatever. Or he may have performance issue, right? Why not you take performance, take action on his performance? So you need to look into a variety of aspects. Now, medical condition includes mental healthness. Yes, mental health issue. So Visa Lini asked this question. Yes, medical condition also includes mental health issue. So people ask me this, right? I've got an employee. I think many of you all would have similar cases happening in your company. I've got an employee, for example, right, this is I'm just sharing. Having mental health issue, depression. Now, we know these kind of issues cannot rewind back, cannot U-turn, cannot go back to, situation where they are perfectly okay, right? It could be a one-way traffic. So what do? Are you going to keep them forever? Or are you going to frustrate the contract after some time? So when I suggested to companies, put them through medical process. If they cannot recover, assessment cannot recover, frustrate. But some companies say, no, we kasihan. So if you're kasihan, what do? Why not you work out a separation package? You tell the employee, right, look, well, your condition is such. Now, I'm going to give you, let's discuss a separation package, and you give them a separation package. At least they have some money, and they can stay at home. You can do that. I know companies have done that. Or if you feel you still want to help them, you don't want to give a separation package, but you are okay to keep them. So what do? Find a job that they can perform, maybe reduce the salary, talk to them, reduce the salary. Now, sometimes, the employee may or may not be aware. So what can you do? Call the next of kin. You don't have a choice here, because the employee is not in the condition to discuss with you, not in the condition to agree with you, etc. What do? Call the next of kin. Call the parents. Tell them that, your daughter, your son is like this. We really cannot manage him anymore. We are prepared for a package or whatever, etc. There is a way out, right? But not doing anything, how long can you do it? When do we say enough is enough? Now, you may argue with me. You may say that, hey, you know what? I think, where's the compassion, right? You are also running a business. How long can you wait? If you say compassion, never mind, you keep him forever. 5 years, 10 years, 20 years, keep. If you say compassion. But there will need to come a time when we need to say, I think this is it. We have accommodated this employee for a long period of time. We have to move on. Okay. Okay. So Kavita, what about privacy concerns regarding employee getting access to medical records? Now, again, today, of course, it's not going to be easy. But in your employment, in your application form, put all these conditions there. Do you agree to go for medical assessment when instructed by company? Do you agree for the company's doctor, not you, I would say we are not qualified. Do you agree for the company appointed doctor to review your medical records as and when needed? If they say yes, you hire them. If they say no, don't hire them. But we never did all this, right? So put this into your into your application form. And in day one, you brief them again. Guys, in the application form, you have agreed you have given us consent, and these are the conditions. They have no choice. Okay, but of course, can you use this to take action on them if they don't want to? You can, but be cautious. Now, staff goes for surgery, right? Staff goes for surgery, 60 days of medical leave. After that, staff requests to work from home as unable to walk. Does the employer have to approve? Now, for sure, you see, if the guy cannot walk, after say cannot walk, how do you ask him to come to work? So in cases like this, he will be on unpaid leave. So you approve unpaid leave, right? Or if the employee still have hospitalization leave, you may need to grant him hospitalization leave because why? After surgery, he's not able to work. He's not able to walk. So he stays at home on hospitalization leave. If no more HL, then becomes unpaid leave. Okay, let me see. Okay, maybe I'll look at Tom's question. Could you explain time slip? Sometimes we go to clinic, they don't give us MC, they give us time slip. Now, by the government hospital or government clinic, as I know, it is acceptable to prove that they went for treatment, but doesn't apply for MC. Time slip is not MC, right? Time slip merely shows that you have gone and seen the doctor. The doctor has given that, doctor is, so-called certified that you have visited him, right? It's an acknowledgement that you have come to the clinic, but it's not an MC. So what do? Again, either he applies for annual leave or unpaid leave. But you cannot use MC, right? You cannot use MC. Why? Because the doctor did not say he's unfit. He's fit, right? So it's either annual leave or unpaid leave. Okay, so let me, again, I saw 2-3 questions. What if the employee don't want to accept a lower job at a different location? Now, first and foremost, now Catherine and also another employee, the lower job should be in the same location. How do you move them to another location? Come on, the guy is not feeling well, right? He's not feeling well. How, and his house, let's say, for example, the employee stays in PJ, factory companies in PJ, and he's gone through his medical procedure, he's not feeling well, or he's not well, and he cannot do he don't want a lower paying job, right? So you, in my view, you frustrate his contract. But if you say, oh, you got to transfer to Johor, come on, he's not medically not well. That decision of yours can work against you, right? For asking an employee who's medically unwell to transfer to Johor, knowing that his doctor is here, his family is here, he needs support and care. So to me, I would be very cautious if I'm going to transfer an employee to another location. Okay, so this is a long question from Marianne David. I have an employee who had an accident prior to Marian joining. So I got to know he had an accident, broke his leg, exhausted his 60 days, and is on unpaid. He was on MC till end of the year. This January, he undergone another operation. That means I need to grant him another 60 days. He said he will take time to recover. He has gone for physio, he's a waiter. His job requires him to stand because he's a waiter. It'll take time for him to require, and at the moment, we don't have any suitable position, right? Any suitable. So to me, in this case, he will be on unpaid leave until he recovers. Of course, when they cross on to a new year, right? December or 2024, sick leave, hospitalization leave, finish. The moment he cross into 2025, he will gain back or he'll earn the 14 days and the 60 days once again. And he can use it. He finish, he goes on unpaid leave, until he goes to the next year, the following year. Okay, maybe I'll take the question, mental health. Now, in this modern era, many companies now offer mental health days as part of their mental leave policy. I mean, it's okay, it's fine. But again, let me tell you this. If an employee is going through mental health issues, depression, anxiety, and this has been going on for months and months and months, your mental health days benefit won't work, right? It won't work. Now, I'm just going to deviate a little bit. Why do employees have mental health issues? At least we discussed this in masterclass, right? That's why if you guys want to change how you work, you want to get on top of things, you want to be better control of processes, join the masterclass, please. So now mental health awareness, mental health. Why do employees get into mental health issues? Why? What is the root cause? Caused by company or caused by employees' personal issues? There could be personal issues, but in some cases, it is also caused by the company. You don't hire the right person. You put in criteria, must be able to speak certain language, must be of certain race, etc. Then you reduce your market pool. Then you hire one of the so-called the better one, but he cannot handle the job. Then you start pressurizing him. Then he becomes he becomes stressed out. Then anxiety. Then depression. Who was the fault? Company. Then you offer mental health awareness day. We have mental health awareness campaign. We buy stress ball. We have lucky draw, a nice cozy corner. All these are not going to help until and unless you resolve the root cause within the company's influence. We will always have these issues. Okay. So let me go to the next question here. Okay, now, what if the employee informed he is sick but rests at home without consulting doctor, unable to provide MC? Is that considered malingering? Possibly can. Why? Because now nobody has certified you fit. The doctor has not certified you unfit. So why are you doing at home? So you got to go back to your policy. If your policy says that, look here, if any days you can't come to work and you think that you're sick, you must give an MC. No MC, it becomes absent. Absent is misconduct. Warning letter already. Right? So you're not coming to, or you apply annual leave. So you cannot leave it empty. So if you are not feeling well, please get the doctor to certify that you're unfit. Give us an MC, we'll pay for it. But if you don't give us anything, right? Therefore, we have to take disciplinary action on you. Or you apply annual leave, right? So you got to decide on one. It's either it's on sick leave or annual leave or unpaid leave, right? If they don't come to work, no MC, it is also considered absent. There goes disciplinary process. Okay, maybe scroll down. Okay, the trend now, okay, this is interesting. Derek asked this question. The trend now is that too many companies is trying hard to please candidates and employees for fear of frequent staff turnover, in a way spoiling the market. Well, to me, employers out there, if you are a serious employer, you pay employees competitively, you run your business with high discipline, you reward high performers, and so on, you don't have to worry about this, right? I don't think companies like Shell, Petronas, Exxon, Nestle need to worry about all this, right? So why are you worried, right? To me, again, I repeat, it is not that you must be a branded company here. Pay your people well. I mean, pay your people competitively, not Elon Musk salary, but pay your people competitively. Give them competitive benefits. Make sure that your discipline is high-level discipline. Reward them if they perform. Train them, develop them, grow them if they perform. If your company practices all this, I don't think there's any fear. No worries. But when you give, let's say we give our pay so-so lah, benefit, cheapskate benefit, no benefit, less benefit, no learning and development. We don't send people for training. Then your company cannot hire lah. Right? So maybe, now, can an employee request a second medical opinion from a non-panel doctor if they disagree with the diagnosis from the employee's assigned panel clinic? This can happen, and one of the cases that I handled personally, yes, the employee challenged our decision, challenged the company's doctor's input. So again, you can do it if you want to, but control the situation. Not his doctor, you appoint a second doctor. You tell the employee, company will appoint a second doctor or another doctor, but not you, right? So that way you are in better control of things, right? If the second doctor says employee is fit, okay, then I would consider employee is fit. But if the second doctor also says not fit, then it's not fit. But you please don't go and tell the doctor, you know what, can you please say it's not, don't do that, right? Be transparent, be fair, and be professional about it. Okay, so let me just answer one more question because it's already 4:29. I don't want to hold you guys back too long. Yep, scroll down. Okay, so so somebody asked this, go. So can you repeat on the limit of medical benefits? So we put entitlement of 1,200 per year. Can we do that? Now, so my darling, right? Not my darling, but my darling. Now, to answer your question is this, EA says you cannot limit consultation, but you can limit medication. So in other words, right, let's say you put 1,002, the employee exhausts, completed, they used up the 1,002. They are, and they become sick after that. By law, you must still pay for consultation. Medication, you tell them, above 1,002, we will not pay for medication. Medication, you pay yourself. Consultation will pay. Some companies also ask the clinic to split the receipt, to itemize the MC. So some companies tell the doctor, MC, can you please write consultation how much, medication how much? So you pay for the medication, but not consultation. So my darling, you may want to check at Labor Department. Okay. Yeah, okay. So maybe just last question, maybe a shorter one, some are two. Okay, yeah, maybe stop there. So why Wan Chen Kaur asked this question? If an employee confirms that an employee is medically unfit to work, they want to go for a termination, separation. How is it necessary to conduct domestic inquiry? Now, remember this, when an employee is not well because of medical reasons, it is not a misconduct. You do a DI for misconduct. You don't do a DI for medical cases. You cannot be calling the doctor, come doctor, got DI. Okay, did you issue this? That is disciplinary matter. But for medical matters, right, you do not do domestic inquiry. Domestic inquiry is only for disciplinary related matters. Even performance, you don't do a DI. Performance, medical is not a disciplinary issue. Performance and medical is not a disciplinary issue, right? If it's a disciplinary matter, not coming to work, tardiness, sexual harassment, stealing, those things are disciplinary issue that you go through a DI. But medical and performance is not a disciplinary issue. Okay, so thanks a lot for joining us today. It's already 4:32. I wish, there's a lot of questions. I wish I can answer all, but I think I hope that this 1.5 hour session is beneficial. So you can download the slides in Facebook, our Facebook community page. You've got the slides earlier on, right? You got the slides earlier on. You can download the medical assessment form, the policy, and many other documents, right? So thank you for joining us. And those of you all, if you're interested in masterclass, please email Sophie, Sophie, at malaysiahrforum.com. Or if you're interested in any of our certification programs, do email us, or you can also get the details from our company website, right? So thank you for joining us, and selamat berbuka puasa for our Muslim colleagues. Thank you.
I would like to take this opportunity to thank Malaysia HR Forum for organizing this AHRP program. I'm also very thankful for the chance to meet many wonderful like-minded people here throughout the program.
Okay, so I also remember about the advice from the CEO of Malaysia HR Forum, which is Mr. Kumar. He always says about AKS, attitude, knowledge, and skill.
So first job, don't berkira-kira, work hard. The first 10 years of your working life, and what I've said the other day, the first 10 to 15 years of working life, it's all about hard work. So first job, grab what you can first, take it up, build your experience, build your competencies, learn the skills that you don't have today. The time will come when something will tell you that it is time to move on.
you have to remember that having qualification doesn't really guarantee you a job, but it can land you with one. But for you to continue climbing the ladder, it's all about skills. And when we talk about skills, of course, not just soft skill, communication, writing, but relates to what you're doing.
What happened between that time until now? I never quit, never lie, and I never want to be somebody other than myself. So if you're a boring person, be boring. If you're an animated person, make sure that animation comes out. And if you're a person that is shy, so be it. The moment you lie, the moment you say you know things and you don't, that's when you won't get the job. At that rate, by the time you are 30, you're going to be having a salary of 7,000 ringgit. Congratulations. But 7,000 doesn't cut it in KL. Learn, continuously improve yourself. This AHRP paper is one of them. Continue to add stuff in your CV.
As a HR professional for many years, the AHRP program, the quality of candidate that we see today, they are well equipped with the confidence, the knowledge and skills of HR, what is it to be a HR person, and all of them coming from other background.
I'm very thankful for Malaysia HR Forum by giving us this opportunity to interview some candidates that they have trained in a 5 days program, and they also filtered the candidates based on their own requirements. And I would say that this is a fresh batch of candidates for us to interview, so it was good. And in a couple of days we will shortlist some candidates and hopefully to organize a second interview with them.
When I first saw it, I thought it was a really good idea to bring candidates together with a specific specialization, which is why I wanted to participate, because I've got HR needs that I'm looking for. So it was a good platform for me to meet a good pool of candidates who have a certification that I can work. Some of them are meeting expectations. As an organization, I'm looking more towards the ability to communicate, looking at critical thinking, character and motivation of the people. So I think for the most part, I've met good people today.
Overall, it's a good experience to participate this HR Recruitment Day. And I think it's a very meaningful event that helps the fresh graduates out there to have the employment opportunity. Overall, I find the session very fruitful, and we managed to get a few good candidates, and we are going to shortlist for the second interview with our company.